or good afternoon. Welcome to the webinar hosted by the National Immigration Law Center. My name is Shiming Shir, and I'm a senior staff attorney with NILC. And we want to thank you for joining us. We know there's a lot going on across the country, especially since this past weekend. And there's a lot that we have to do to really defend our immigrant communities from the various attacks that we're facing. So today's webinar is going to focus mainly on the DACA program, Deferred Action for Childhood Arrivals, and what is happening with the program in terms of attacks, as well as a lot of the work that's happening through advocacy and through grassroots mobilizations to defend the program. So our first speaker is going to be Ignacia Rodriguez from NILC, who's going to talk about the work that's been happening to defend DACA and also some of the bills that have been introduced in Congress. So Ignacia?
Thank you, Shiming. Hi, everyone. It's a pleasure to be on this field call today. As Shiming mentioned, I'll be going over the advocacy work around defending DACA, and then also briefly going over some of the bills that have been introduced that relate to the DACA program. So first, it's my pleasure actually to introduce that we now have a Defend Our Dreams campaign. So there's been a lot of really great work that's been done in partnership. At NILC, we've been able to partner with United We Dream, with NACASEC, with Forward.us. I mean, the amount of people that are willing to do this work is really amazing. But of course, we want to make sure that we're doing things in a centralized fashion, and that's why the Defend Our Dreams campaign has officially launched. And the campaign manager is Sylvia Reese, pictured here. Sylvia has many years of experience organizing, including in unions. And so collectively, all the partners will be working towards this campaign. Listed here are the campaign goals. Using field communications, federal and state level advocacy, and litigation strategies, our primary campaign goals are to, first, secure protections and benefits for undocumented immigrant youth who benefit from DACA. Two, leverage threats to the DACA program and detentions and deportations of immigrant youth to redefine the national debate on immigration, to highlight the stories of people who have benefited from DACA and who will be impacted if Trump were to terminate the program, and the positive contributions that dreamers and immigrants make in our communities, as well as to forcefully refute false narratives regarding the threats that immigrants pose to American society. And lastly, to build broad-based opposition to efforts to dismantle DACA and ramp up detentions and deportations of dreamers, and highlight how such policies erode fundamental rights and run counter to the values of freedom, justice, and opportunity upon which the United States was founded. So be on the lookout for more materials and information from the campaign. If you wish to be part of the campaign, please reach out to us. We'd love to work in partnership. And here are some opportunities for folks to get involved. So one is you can check out the toolkit that NILC and the Center for American Progress created, which includes sample press releases, statistics, and other information that you can share with your state and local elected officials, encouraging them to support the cause and to defend DACA. You can also sign and circulate a petition telling Trump to defend DACA. You can tell members of Congress to also show their support, including actually showing up to town halls in your own town, encouraging them to show their support. And when we share these slides, you'll have links to each of these opportunities. So for example, for the town halls, you'll have a link that will indicate how Indivisible and how United We Dream, how they would proceed. They have materials to share, so if you've never done it before, they actually walk you through the process. And also share your story. If you have DACA or if you've made contact with a DACA recipient, feel free to share your story with us. We'd love to hear. We've gotten so many great responses from individuals sharing how DACA has changed their life, and we've also gotten great responses from community members and from educators talking about why it is that they support DACA. But there's still, people that have questions regarding what do I do now that there's all these possible threats to DACA. Should I apply for the program anyways? Should I apply for renewal? So feel free to visit our website for materials on those topics. And if you want to know what the threats are, which we will talk more in depth about later, we also have materials on that topic. And lastly, I just want to highlight that a lot of groups are thinking through actions between now and September 5th. September 5th is the deadline that Paxton and the other attorney generals gave the government to wind down the DACA program. And if they don't, then they would present a challenge to DACA in the courts. And so a lot of folks are taking this as an opportunity to encourage people to show their support for DACA between now and September 5th, and to really do everything that we can to push the administration to keep the program. And so we encourage you to use the comment box here on the webinar, to use the Q&A box, to share what you're doing between now and that date, and even past that date, to show your support for DACA. And now I'm going to transition and talk about DACA-related bills that have been presented. What's really great to see is that there's been a bipartisan effort to push bills forward to protect this population. But there are many out there, and so I'm going to talk a little bit about each, but I encourage you to read the actual language of the bills if you can, to go on our website and check out our comparison chart, which tells you what the differences are between these bills. And that way, within your organizations, or just personally, you can think through, if there's any that you personally or your organization would support and would want to mobilize around. So the first one I want to talk about is Bridge, the Bar Removal of Individuals Who Dream and Grow Our Economy Act. So this bill was introduced again on March 9th by Corbello. It does not offer a pathway to citizenship, so it's really important for people to keep in mind. It's only allowing those who have DACA to be able to keep it, and those who meet the DACA requirements to be able to apply and get this status that is essentially the same, but now it's provided by Congress, which is a benefit. But there's no path to citizenship. There's nothing like that in the bill. And at most, the bill, if it were to pass and be enacted, it would only be available for 3 years. So let's say Congress passes it in 2017. That means that it would only be an option until 2020. So it's limited in time. Then there's also the introduction of the DREAM Act, actually in both the House and the Senate. And here we have listed the senators and the representatives who introduced it. The difference here from Bridge is that DREAM does provide a pathway to citizenship. So first you would have conditional permanent residency for 8 years, and you would need to fulfill a series of requirements to get that status, which we'll go over. And then you can apply for LPR status and have that for about 5 years, and then be eligible for naturalization. So the process could take about 13 years. And to be eligible for conditional permanent residence, a person must have no lawful status or have a final order of removal or have TPS or have DACA. 2, have entered the United States before turning 18. 3, earned a high school diploma, state equivalent, or a GED certificate, or enrolled in a secondary school program to obtain a high school diploma or GED, or be admitted to an institution of higher education. 4, be continuously present in the United States for at least 4 years before the date of the enactment. 5, not have committed certain criminal offenses and pass the background check. And DACA recipients become CPR automatic automatically by having DACA unless they have engaged in some kind of conduct that would make them ineligible to continue having DACA. So those are the requirements. They're a lot more generous than in the past iterations of the DREAM Act. And then after you have CPR status, there are an additional set of requirements that you would need to meet to go from CPR to LPR status and then citizenship. So you can apply for LPR status after 8 years of having CPR status. You must not have any criminal issues, which are actually outlined in the Act. You must not have abandoned your residence. So there is a continuous residence requirement that's also laid out in the Act itself. And you also must have completed one of the following. So there's an educational, a military, and a work component to the bill. The educational requirement is acquired a higher education degree, completed at least 2 years in a bachelor degrees program. Military, you must have served in the armed forces for at least 2 years. The work requirement would be been employed for a total of at least 3 years, and 75% of which you must have had valid work authorization. So let's say if you had a work permit through TPS or through DACA, then that would satisfy that requirement. And there's also a hardship exception. So for example, if the applicant has some kind of disability or is a full-time caretaker of a minor child, or if there's other extreme hardships that they can show to someone who's at least lawfully present in the United States, then they may be able to qualify for an exception. But the applicant ideally would meet one of these 3 requirements. And then as all other normal processes that go on, except for family sponsorship through marriage, you would then be able to apply for naturalization after 5 years of having LPR status. So now we're going to talk briefly about the HOPE Act, the American HOPE Act of 2017. That was introduced by Representative Gutierrez and other representatives from the House. It also offers a path to citizenship. The timeline is slightly different. So you would get conditional permanent residency for 3 years, LPR for 2 years, and then after a minimum of 5 years, you would be eligible for citizenship. So the step-by-step is the same, but the timeline is much shorter. And then to be eligible for conditional permanent residency, which is actually valid for 8 years, the person must prove that they entered before turning 18, been continuously living in the U.S. since at least December 31st, 2016, not have any lawful status or be in removal proceedings, have previous order of removal, or actually can show that they're a DACA recipient, not be convicted of certain crimes and be able to pass the background check. So if you notice, similar to what I just went over, the requirements for conditional permanent residency under the HOPE Act are more generous than the requirements of DACA, right? With DACA, you have to have entered before the age of 16. Here it's 18. So the idea is hopefully more people will be eligible if that's the requirement that stopped before from being eligible for DACA. But still, there are requirements that a person must meet after getting CPR status and then transitioning to LPR status and eventual citizenship. So the person can apply much sooner to have LPR status. They just have to have that status for 3 years, CPR status for 3 years. The person must not have abandoned their residence in the U.S. while having conditional permanent residency, must not have committed certain criminal offenses, which are outlined in the Act, and be able to pass a background check. Unfortunately, any time spent under DACA can count towards that 3-year CPR requirement. So here we listed an example. If you apply for conditional permanent residency, having had DACA for 2 years, you will only need 1 more year with CPR status to then be eligible to apply for LPR status. And then you're eligible for naturalization after conditional basis is removed, and time in CPR may be applied towards those 5 years to be able to apply for citizenship. So I know this all sounds really complex, which is why I encourage you to do go to our website and be able to see our materials. The table that compares all the bills lays this out a lot more clear, but also I encourage you to actually read the language of the bill as well, because that goes more into depth on the requirements, and be able to assess for yourself what your position is on these bills, and be able to make that decision on your own. Shimei?
All right, thank you, Ignacia. And for those of you on the phone, if you have questions, you can just type them into the chat box, and we'll be going over the questions towards the end. We'll leave at least a good 15 minutes to answer your different questions, and we will send you a copy of the PowerPoint tomorrow so that you can click on all the different links and take a look at the other resources. So next we have Josh from NILC, who's going to talk about the legal challenges to DACA.
Thanks, Shiming, and thanks everybody for joining the call. My name is Joshua Stalick. I'm a supervising attorney here at NILC. And as Shiming said, I'm going to talk about potential legal challenges to the DACA program. I want to start with a caveat that there are many what-ifs here, as we don't know what position the Trump administration is going to take with regard to the constitutionality or legality of DACA. The administration has been somewhat all over the map in terms of their position around DACA more generally. As folks on the call probably know, Trump did run on a campaign of rescinding DACA, but soon after the election did somewhat backpedal from that position and made some ambiguous statements about working things out for Dreamers. And as folks know, of course, did not rescind the DACA program after the inauguration, and in fact, it remains in place and operative. More recently, then DHS Secretary Kelly also made some ambiguous comments that seemed to support DACA recipients, but also cast doubt on the administration's position as to whether the DACA program passes constitutional muster. So we really don't know where the Trump administration is going to land with regard to the legality of the DACA program. And there are two pending legal cases in which the constitutionality of DACA could be directly challenged, and I'm going to talk about those in more detail. I did want to flag that NILC has put together an informational document about these various legal scenarios, which is linked to on a prior slide, available through our website, and we'll also send a link to it in our follow-up email to this webinar. So the first threat is in Texas v. U.S., and this threat grows out of an existing case, the Texas v. U.S. case, which did then switch to be called U.S. v. Texas as it made its way through appeals up to the Supreme Court. And as folks on the call may remember, this was the case in which Texas and a number of other states challenged the legality of the DAPA program, Deferred Action for Parents of Americans, and the expansion of the DACA program, which then President Obama had announced in late 2014. And to this point, the case has not involved a challenge to the underlying or the original DACA program as announced in 2012. As folks who followed that case probably will remember, the judge in that case, Judge Hanen, is on record as strongly opposed to Obama's administration policies, which he condemned in highly charged language in a totally separate case. And Judge Hanen did block DAPA, the Deferred Action for Parents of Americans, and expanded DACA from going into effect. And the Fifth Circuit affirmed that decision. And then the federal government appealed to the Supreme Court, which then deadlocked in a 4-4 vote because at the time Justice Scalia had passed and a ninth justice had not been seated. So we only had 8 justices on the court at that time, and they tied. And so that means that the Fifth Circuit decision affirming Judge Hanen's block of DAPA and expanded DACA remained in effect. So that case has been stayed, or in layman's terms, basically paused since that Supreme Court decision while the change in administration occurred. So that case has still remained live, although it's been on hold since the SCOTUS decision. Fast forward to June 29th of this year, 2017, when Texas and 9 other states sent a letter to Attorney General Sessions threatening to challenge the legality of the DACA program unless the Trump administration agrees to end DACA by September 5th. And currently, or most recently, you may have seen Judge Hainan did extend the stay in that pending case until September 5th. So Texas v. U.S. is currently on hold until September 5th. So there are various scenarios as to how this could play out. One is that the federal government or the Trump administration could agree to end DACA by the deadline that Texas and the 9 other states have given the federal government of September 5th. The federal government could decide not to end DACA, in which case, if Texas follows through on the threat made in this letter, it would then be asking Judge Hainan, which is the same judge that blocked DAPA and the expansion of DACA, to add a challenge in the Texas v. U.S. case to the original DACA program. Or finally, MALDEF, the Mexican American Legal Defense and Education Fund, is a party in the Texas v. U.S. case and represents DAPA eligible individuals. And earlier this summer, MALDEF asked the court to dismiss the case since DHS has since rescinded the memo creating DAPA and the expansion of DACA. And so MALDEF is arguing basically that the issues that have been presented in Texas v. U.S. to this point have been resolved by the rescission of that memo. So it is possible that Judge Hainan could grant MALDEF's request to dismiss the case. So that's Texas v. U.S. And then there's a separate legal case that's pending in which the legality of DACA has been raised, and that is the Arizona DREAM Act Coalition versus Brewer. And this is a case that NILC is counsel on, along with the ACLU and MALDEF, and it's a case that involves driver's licenses for DACA recipients. So Arizona was one of the very few states ultimately after the adoption or the initiation of the DACA program to refuse ultimately to grant driver's licenses to DACA recipients. Arizona had previously granted licenses to applicants whose presence was authorized under federal law, but denied them to DACA recipients until they were ordered by the courts to issue driver's licenses to DACA recipients as part of this case. And Arizona did not raise a challenge to the constitutionality of the DACA program until later in the litigation when the case was already on appeal to the Ninth Circuit. So Arizona did petition the Supreme Court to hear the case, and the Supreme Court in response has asked for the views of the current Solicitor General before the Supreme Court decides whether or not to hear the case. As folks on the call probably know, the Supreme Court has discretion to decide which cases it hears, and so it hasn't made a decision as to whether to take the ADAC case or not for hearing, but instead has asked the current Solicitor General to weigh in before the Supreme Court makes that decision. There's no deadline that the court gave by which the current Solicitor General must respond to the Supreme Court, but it can take, on average, up to 4 months for the Solicitor General to file its views with the Supreme Court, which it has not yet done so. So there are several potential scenarios here as to how this could play out. So the Solicitor General could recommend that the Supreme Court not take the case. The Solicitor General under President Obama argued to the Ninth Circuit that Arizona did not properly raise the question of DACA's constitutionality because they essentially raised it too late in the litigation process. and also argued that the DACA program was well within the president's power, and the Ninth Circuit agreed with the Solicitor General on that. The current Solicitor General, however, under President Trump, is not bound by the prior Solicitor General's opinion, so could take a different position. And if the Supreme Court declines to take the case, then the Ninth Circuit ruling, which required Arizona to provide driver's licenses to DACA recipients in Arizona, would stand. But DACA could still be vulnerable to other legal challenges in that situation, like the Texas v. U.S. case, which I just spoke about, or to the administration rescinding or terminating the program. The Solicitor General could recommend that the Supreme Court take the case, and if the court then agrees, the court would potentially then be asked to decide DACA's constitutionality. Previously, as I had mentioned earlier, the court had deadlocked 4-4 in U.S. v. Texas around whether DAPA and the expansion of DACA was constitutional, but the court now has a ninth justice, and so we could see then a majority opinion of at least 5 justices. Even if the court takes the case, it's unclear whether it would ultimately decide DACA's constitutionality, since the court could make a decision based on other legal principles or could find that Arizona raised the question of DACA's constitutionality too late in the litigation for it to be decided. If the court does agree to take the case, it's unclear when it would hear oral arguments in the case and then when it would issue its decision. It could be as late as June 2018 when the Supreme Court term that begins this later in September of this year ends. So the Supreme Court term starts in later September and then runs through June of 2018. So those are really the 2 cases I think that present the most acute potential challenges to the DACA program. And as I've said, there are still a lot of what ifs, and we don't know how it'll play out, but we do expect that there will be movement between now possibly and September 5th, and certainly we're looking to September 5th as a key date in the process. Thanks.
Thank you, Josh. And next we have a special guest to talk about NACASEC's work around defending DACA. So we have with us Sukyoung Oh, who's the DC Area Director for NACASEC. So Sukyoung?
Yes, hi everybody. So I am talking to you from at Morrill Park. NACASEC, we are a national organization whose mission is to organize Korean and Asian Americans for racial, economic, and social justice. We have worked with undocumented Korean and Asian American communities for close to 2 decades now. And when our young folks and community members heard about what is the situation with DACA, and in our analysis, we felt that we needed to strongly respond with an action that reflected our commitment to the young people and their families and the communities that benefit from DACA, and to protect DACA, the program itself. So on August 15th, we launched a round-the-clock 22-day presence in front of the White House to demand that President Trump and Congress defend DACA and the state CPS. So whether it's 2 p.m. in the afternoon or 2 a.m. in the morning, there are young people and community members constantly in front of the White House with signs. They're drumming, we're dancing. It's nearly 100 degrees today, and we're out there. The other actions that our faith partners in particular are taking a lead on are daily prayers and blessings at 8:30 a.m. and 5:30 p.m. at Morrill Park, which is our base camp located 3 blocks away from the White House. And that's where I'm calling you from today, and so you might be hearing some traffic and whatnot. So again, we wanted to, we we wanted to create an action that reflected the strength of our commitment, that really targeted the White House and President Trump and his administration. That was really the benefit of this action. Here are some photos. The photo on the upper right was really hot outside, so we needed some shades. We got some umbrellas, but then made them into picket umbrellas, DACA. And there's a photo of some of the folks who are out there overnight, holding vigil in front of the White House. Next slide, please. Next slide, please. All right, great. Thank you. So we've been getting lots of questions. Folks want to know how to support, because we'll be here for, I guess now it's 19 more days. Yeah, it's until September 5th. So what are ways that folks can support? So if you're here in the DMV area, come meet us at the White House. Whether it's 2 p.m. or 2 a.m., we're there. Please help to promote the action on Facebook, Twitter, our website. Our hashtag that we're using is DreamAction17. We're also really so pleased that I think as of today we have about 11 sponsors, including United We Dream, the Franciscan Action Network, Church Full Service, Faith in Public Life, and over 30 endorsing organizations. And you can see all of that on our website that's listed on the bottom of the slide here, www.nacasec.org. We are also collecting petitions while we're out here, and we'll be coordinating a White House petition drop shortly. So go on our website, sign and circulate the petition. Another way to support is so specifically this action is really any type of encouragement, donations. We're talking stories, notes, snacks, meals, Trinella candles. It's very mosquito-y in DC, particularly at night, etc. So all of that information you can find on our website, nacasec.org/act. You can also contact me directly, and I think maybe our contact information will be shared on the last slide or whatnot. But if not, my contact information is S as in Sam, OH, @nacasec.org. Next slide, please. So yeah, this is a pretty bold action, but we feel that at this moment that's what is needed: bold action. Some other ways to defend DACA, which was brought up earlier in the call, and which we've at NACASEC have been also helping to uplift. So joining a local action, there's that website again. Here at NACASEC, we worked with our Virginia Attorney General to make a public statement in support of DACA. So if you're in a state where either your representatives, your senators, any local elected officials, like the Attorney General, has not made a public announcement supporting DACA and CPS, now is the time. And of course, to co-sponsor the DREAM Act. Thank you.
Thank you, Suk-Young. And hopefully you can stay on the line a little bit longer for us to take some questions. And Zara,
sure.
Are you on the line?
Hi, this is Zahra. Yes, I'm on.
Okay, great. So I will let you talk about the next section regarding different activities related to the Muslim and refugee ban.
Absolutely. Thanks, Shuming, and to everyone for being on this call, but also for creating space for a conversation about the Muslim ban. I think what's felt most important to me, and maybe to many of you, even urgently this week, has been the need for us to be building across movements and issues. And so if we're resolving one issue and not the other, or vice versa, then are we really moving forward? And so in that vein, CARE Bay Area is working with NILC and Advancing Justice Asian Law Caucus on some of the work leading up to the Supreme Court fight on the Muslim ban. For those that are less familiar, actually it's been a few months since it's been on the news, some background on that is that remember there was a lot of lawsuits filed to challenge the Muslim ban. There were cases that went all the way to the Fourth Circuit and the Ninth Circuit. Both of those cases are now being consolidated and will be reviewed by the Supreme Court. In the Fourth Circuit case, NILC and the ACLU are co-counsel, and they represent IRAP, Hayek, and others. And then in the Ninth Circuit, the government of Hawaii represents the state. There are a lot of different scenarios that can play out over the next few months. A key thing, of course, leading up to Supreme Court argument is the very real possibility that Number 45 will do something unpredictable. That has been much of the case this week, but also in the past few months and really since he took office. Arguments, though, are on Tuesday, October 10th. Decision could take weeks or months. We anticipate worst case scenario, it'll be that it takes until June to get a decision. The judges will first meet to conference about the case on the Friday after the oral argument. So on 10/10 is oral argument. That's Tuesday. On 10/13 is the conference about the case. And so what happens leading up to 10/10 and in the days that follow it will have an impact and, of course, will influence the judges, but also the media coverage and the way impacted communities feel about what's going on. We see this as a rare but also incredible opportunity to put faces and voices to Muslims, refugees, and others who have been spoken about so negatively by this administration and really have been at the center of what's going on, but many times have not been the faces representing what's going on. A study by Media Matters in the weeks following the first Muslim ban showed that I think over 90% of the commentators on cable news network about the Muslim ban, so not the hosts, but the guests that would come on, were not from impacted communities or countries. And so our hope is to really center and amplify people from the 6 banned countries. That's Iran, Syria, Somalia, Libya, Sudan, and Yemen, as well as those who are refugees, and put them at the center of a longstanding fight for justice for Muslims in this country. And we hope that by extension that will protect the rights of all people. So we want to build momentum, buzz, and conversation leading up to October 10th and on the day of. There is actually a large action planned at the Supreme Court on October 10th. Being led by our colleagues at a group called Empower Change, and they've pulled together a steering committee and will soon be doing a call out for endorsements. And so if you're in the DC area, we'd love to have your support for that. And if you're in another community where there is a large Muslim, Arab, South Asian population, we're also going to be pushing for some local actions to amplify the story across the country. Again, a big theme of this for us is to connect the community to the litigation and connect different regions to the litigation in a way that sometimes gets lost around Supreme Court litigation. On your screen, though, you have some other dates leading up to 10/10 that we have flagged as important. So on September 1st, for example, is a Muslim holiday, Eid, but there's also a National Day of Action around Texas Law SB4 going into effect. Really between now and 9/5, we have time to talk to members of Congress. The briefs, some of the initial briefs in the Supreme Court case are due on 9/11, which is also the 16th anniversary of 9/11. There's National Welcoming Week, Constitution Day, and then on 9/27, that'll be 90 days of the Muslim ban. So it's a different date that we're watching closely. Again, because when the first 90 days lapses, it creates an opportunity for the administration to go in and do something different. On the next slide, it's more about the 10/10 mobilization. So we've talked about DC. Our hope is a large action outside of the Supreme Court on 10/10 with the possibility of a march to the White House. That'll be a Tuesday morning, and so we're hoping that folks from the DMV area can come to the event and mobilization. We want to replicate and really grow what we saw happen at the airports in January, and we'll also be working on busing people in from across the Northeast. So initially I said if you're in DC and want to come, do that. But also if you're in New York, Chicago's not Northeast, but New York or somewhere near, then you want to bus in, please, contact NILC, and we're happy to connect you to the right people. And then other cities that we've already identified as starting places for parallel actions include Los Angeles, Detroit, Seattle, Atlanta, San Diego, or New York City. So if you're in any of those cities, we'd love to link you up to people on the ground doing that work so that we can really build, again, a cross-movement mobilization on 10/10. And if you're in a city that is not listed, but are, have some capacity to help with an action, and again, really bridge these conversations and center impacted communities, please let us know. We know that the media will focus intensely on our administration and everything absurd that they're doing, but we want to make sure that we use this hook of the Supreme Court argument to empower the people really at the center of this, put forward authentic human voices about who is impacted, and use it as a moment to empower people who are dealing with all of this, so that they leave 10-10, no matter what the final outcome be, or no matter how the argument leaves, feeling like they are strong, like they are in control, and that they are supported.
Thank you for sharing that. And, we all know that the Trump administration is targeting many groups, so we wanted to connect the dots a little bit and talk about the work that's ongoing to really support multiple communities of color. And along those lines, I know in the NACA slides, there was a discussion of TPS. I don't know if Suk-Young or Ignacia, one of you want to just explain to people who might not know what TPS is and why it's important to try to make sure we extend it.
So I can start, and folks feel free to chime in after. But yeah, so temporary protected status, TPS, it's a process that people from certain designated countries can apply for, and allows them permission to remain in the United States for 1 year at a time. So every year they have to wait and see if it'll be approved again. They also get a chance to work in the United States, they get a work permit. So it's similar to DACA in that sense, if you're more familiar with that process. And the countries that can qualify for TPS are designated. And it tends to be because there's been some kind of natural disaster or some other emergency that doesn't allow the individual to be able to return to their country of origin, and therefore they're allowed to stay in the United States. But because it is a discretionary form of relief, it's not a guarantee that it will be reissued.
All right, thank you. And we have a question for Josh around the timeline. So there's been a lot of talk about the September 5th timeline. If DACA is still around on September 5th, how quickly would things move on the legal front?
This is obviously a little bit of speculation, but I would presume that Texas and the 9 other states that sent the letter to Attorney General Sessions would be ready to file. They'll have to ask the court for leave, essentially, to amend their case to include a challenge to the original DACA program, since that's not been part of the case up to this point. But I would presume that Texas and the 9 other states that joined that letter will likely file very quickly after September 5th if the administration hasn't taken any action. And then that would initiate a briefing process that we would expect would move somewhat quickly. And given the actions Judge Hainan has already taken, we don't know what decisions he would make, but it does seem likely that he would be potentially amenable to including a challenge to the original DACA program and to expediting the timeline for that to move forward. So it's really speculative, but we would expect that Texas would move pretty quickly after September 5th, including as early as like September 6th, to initiate the process to essentially amend their current case to include a challenge to the original DACA program. And at the same time, then we would expect to see potential movement in ADAC as well. And I should add that NILC and other partner organizations are exploring legal strategies, including litigation strategies, to try to protect DACA. And so we are currently in the process of researching and thinking through what sort of litigation strategies, potentially apart from Texas v. US and ADAC, or as part of those cases, could be deployed to try to protect the DACA program.
Great, thank you. And a question for Sara, is there some website or some clearinghouse where people can get information about the different mobilizations leading up to October 10th? She might not still be on the line, so we can hold that question. And there's one question about why there's efforts around defending DACA when it's only an action from the administration and not a law. So the question is, what are the chances of a bill like the DREAM Act passing, and why aren't we fighting more for bills like the DREAM Act? Maybe Sikyong or Ignacia, you want to take that?
Sure thing. So I can provide like a broad overview, and then I'd love to hear what Sikyong has to say about the topic. But yes, there is a lot of legislation that's being introduced related to the DACA population in particular, because Congress can pass something that's more permanent, that has a potential path to citizenship. It wouldn't be as vulnerable as DACA is now, in the sense that the president can announce it just as easily as the president can take it away. If something were to pass through Congress, then it would be up to Congress to then present a bill that would end the program. So there would be more of a process there to end the program. As far as like the chances of it passing, the chances are quite slim, just because of the composition of Congress right now, but that's subject to change. So if enough political pressure is applied, if there is an attack to DACA that pushes the congressional members to actually take action, I mean, that can up the chances of DREAM, HOPE, or any of these bills to pass. The question is, what would be the conditions of getting relief through DREAM, through HOPE, et cetera? Because before a bill becomes a law, it has to go through a series of committees, amendments are made, and we don't know yet if they're going to add, for example, enforcement provisions, or if they're going to try to make those who qualify for these types of laws ineligible for the ACA. So all that, we don't know yet. It's to be determined, and that's why now a lot of organizations seem to be having conversations around, what will they support these bills? Will they engage in mobilizing people to support these bills? And what will be the conditions that they're willing to take or not take if an amendment were to be made to these bills?
And I would just add, this is Josh, that we at NILC really see the need to defend DACA. I mean, obviously as crucial, given that it's protected over 800,000 young immigrants in the U.S. and allowed them to contribute more fully to their communities. But we don't see sort of the litigation strategy or the focus on DACA as separate from the advocacy around the various bills that are pending in Congress that would provide a more stable and potentially permanent solution. We really see the need to work holistically, both to defend DACA while potentially advocating for a legislative solution and engaging and mobilizing grassroots organizing and communication strategies to lift up the voices of DACA recipients, both to protect the DACA program and in support of a potential legislative solution.
Thanks. Sikyong, did you want to add something?
Yeah, hi, this is Sikyong. I mean, for us, right, like why are we doing this work? We're doing this work because we probably all know or know of an amazing, undocumented young person who is just trying to figure out what they can do with their life and, live their life to the best that they know that they can, and we know that they can. And, we have this very real program in front of us, DACA, which we know works and has really, we already know all the economic and the social benefits that it has brought to this country and, and to these young people and their families. And DREAM Act, yeah, there is that. If that could be a permanent legislative solution. So I think for what's really driving NACASEC for this action is called DREAM Action, right? Our youth, our future is we're here to defend DACA. We're also very aware, right, of the how TPS is a kind of a similar situation, and any type of cancellation of either program really creates would be really bad for the other. And yes, we're also out here asking folks to support the DREAM Act. So I know it seems like a lot, but I mean, generally, right? We're here thinking about citizenship for all people, but we know that, and we're starting with DACA and TPS. They're very real programs that work now, and of course, continuing to promote the DREAM Act and other types of permanent legislative solutions. I hope that makes sense. It's like really hot, and I think I'm getting a little delirious. I should drink some water.
No, yeah,
just kidding. It's not that. It's not that bad. If you come out and join us in front of the White House, definitely wear a hat or bring some shade. It's very sunny right now.
All right. We won't keep you on too much longer, but I don't know if you wanted to talk a little bit more about the threats to TPS, or if Ignacia, you wanted to talk about exactly why we feel that the TPS program may not get extended for certain countries.
Yeah, I can go first. Again, people feel free to weigh in. But yeah, so unfortunately, DACA is not the only program being challenged right now. TPS, which I described earlier, is also being threatened. So under the administration, we've actually had a first round of threats to the designation for Haitians. And during that time, we saw a lot of behavior that's quite questionable, including officials from the government asking for information on the number of Haitian nationals that use public benefits, what their crime rates are, and this was through exposed leaked emails from high-ranking DHS officials. And then there was also advice that was given to the secretary to end the program, essentially arguing that there's no longer a need for Haitians to be designated as having protection under TPS, and it's safe for them to return, and so they should wind down the program for them. Ultimately, the secretary decided to extend the program for 6 months, but after those 6 months, we don't know what's to happen. And then there are other countries that are up for redesignation, and the secretary will have to make a decision as early as the fall for those countries, and also make a decision on Haitian TPS around that same time. And we're conscious that a decision will have to be made, and we're fearful that it will be, a decision that to end TPS for all, or for a large chunk of these countries, and that's why there's a lot of really great work being done, to name a few, by United We Dream, by Indaki Black, Mecaresin, to be able to really argue why these programs should remain in place for all.
All right, thank you. And we had 2 questions related to Attorney Generals for Josh. One is, so there were other state attorney generals who joined the initial Texas v. U.S. litigation. Do we think they're going to also support this challenge to the DACA program? And the other question is that there's been rumors that the 10 attorney generals could bring litigation before September 5th. Do you know anything about that possibility?
I mean, on the latter question, we don't have any intel. I mean, the letter did give the administration until September 5th to respond, and that was the date by which they asked the administration to agree to terminate the DACA program, or else they would move forward with amending their case. They could decide theoretically to file prior to September 5th. I mean, they're not bound by the date that they gave in their letter, although it would seem, I guess, so I think it is a possibility, but given that they did give the administration until the 5th, we don't know whether they're going to sort of abide by the their own deadline, or if they could preemptively file prior to that. With regard to the prior question, so as folks may know, in Texas v. U.S., Texas was spearheading that challenge to DAPA and the expansion of DACA, and ultimately, I believe it was 25 or 24 additional states or state attorney generals did sign on to that lawsuit on the side of Texas, whereas only 9 other states, in addition to Texas, signed the letter to Attorney General Sessions threatening to amend the case to include a direct challenge to the original DACA program. So I think obviously there's at least then, well, I'm a lawyer, I'm not great at math, but we have, so there are like 14 or 15 states who signed on to Texas v. U.S. who did not sign on to the letter to Attorney General Sessions in late June of this year. And I think it's a very open question whether all of those states would then remain in the case, or if we could see some of them potentially withdraw from the case if it is indeed moving forward to present a direct challenge to the original DACA program. And I think that that's a good point in terms of potential public intervention here. I think there is the opportunity right now for folks in states that signed on to the Texas lawsuit, but haven't signed on or didn't sign on to the letter to Sessions in June, to make their voices heard, to advocate with their elected officials in the state, to refuse to sign on to an expansion of the lawsuit to include a challenge to DACA. So I think it's really an open question whether those 14 or 15 states that were part of the original lawsuit but not part of the recent June letter, whether they would continue in that suit if it's expanded to challenge the original DACA program directly, and a good point of intervention now.
So the last question before I share some resources, it's actually the same question from 2 different people, which is a concern that when people apply for DACA, especially under this administration, that their information could be used to deport them. So Sukyung or Ignacia, what do you usually say to people who have that concern?
Hi, this is Sukyung. You know, I mean, ultimately, it is, we've had community members who have gone forward with applying, despite the potential risk, because they see that DACA renewals are still being processed. And, you know, we have partnered with local legal aid organizations to really make sure, because, you know, it's a very personal decision, right, whether to go forward or not. And we've had others who have decided not to. And we're certainly reaching out to all of the documented youth that we know and have helped process their applications in terms of, like, you know, renewing it, barring any, you know, serious issues that may come up since they initially applied. So it's just a conversation you have to have with each person. I don't know if that's a very, very good response, but I think it's because there's not really one good way to talk to people. I mean, there's no one way to counsel folks on this, if that makes sense.
Yeah, that makes sense. And I just wanted to add that currently USCIS's policy is that it does not share information about a DACA applicant or the applicant's family members with U.S. Immigration and Customs Enforcement, ICE, for immigration enforcement purposes, unless there are serious criminal fraud or national security issues with the case. And this policy has been in existence for many years for deferred action in general, but actually stated as part of the DACA program in 2011. It is subject to change, but it's important to note that people have relied on these statements, have submitted their applications, their information, trusting the government's policy, And so we believe that that policy must remain in place.
Thank you. And so just to conclude, we wanted to share with you some resources. With all the concerns about ICE arresting increasing numbers of people, we've created a toolkit for healthcare providers to create safe spaces within their facilities. So there's a link to the toolkit. You have to register to actually be able to download it, and it goes through a lot of different resources and suggestions for healthcare providers around how to create safe spaces, and also know your rights resources for patients. And our second to last slide has links to some of the documents we've mentioned related to DACA, and also a document we have regarding the Supreme Court's action on the Muslim and refugee ban. So as always, feel free to contact us if you do have any further questions, comments, or suggestions. And we really do urge you to take one of the steps that we've outlined to either support the mobilizations against the Muslim and refugee ban, or to defend DACA and defend TPS also. So thank you all.